You are walking home at night, and a police cruiser rolls up beside you. An officer steps out and says, "Hey, got a second?" Your pulse jumps. You stop, you answer their questions, and you probably hand over your ID. We do this because we are socially conditioned to view that uniform as an automatic command for compliance. But at this moment, the officer is often operating in a gap between their legal authority and your assumptions. If they haven't seen you commit a crime, they have no power to make you stay, but they rely on your politeness to keep you talking. You can close that gap by asking one specific question. Am I being detained? Those 5 words function as a tactical mechanism. They move the encounter out of social etiquette and into a rigid, legally binding framework, where every action must be justified on the record. Under the U.S. Constitution, there are exactly 3 categories of police interaction. By asking the question, you force the officer to choose which category they are operating in. The first category is the consensual encounter. As we see in this conversation between a citizen and a metropolitan police officer, the interaction is purely voluntary. You are free to ignore the questions and walk away at any time. The moment an officer answers yes to your question, the encounter changes. It escalates from a voluntary conversation to a mandatory detention. This is Tier 2, the detention. Based on the Supreme Court ruling in Terry v. Ohio, police can briefly hold you and even perform a frisk like the one shown here, but only if they have reasonable suspicion that you are involved in criminal activity. There are strict limits to this. A detention must be brief, and you are not under arrest. While some state laws might require you to identify yourself, the officer cannot perform a full search of your person or your property without more evidence. By forcing the officer to confirm you are detained, you force them to articulate a specific legal suspicion on the spot. If they can't, they lose their authority to hold you. The final category is Tier 3, the arrest. Taking someone into full custody, as seen here, requires the highest street-level standard, probable cause. This stage triggers your Miranda rights and firmly establishes that you are being held as a criminal suspect. This structure creates 2 clear outcomes. If you ask the question and the officer answers no, the interaction is over. You can simply turn around and walk away. If the officer answers yes but lacks the facts to justify a detention, the encounter shifts from a lawful stop to a constitutional violation. Forcing the officer to verbally commit to a specific tier eliminates the ambiguity of the situation and creates the exact factual record needed to hold the government accountable later. But what happens if an officer says you aren't detained, yet continues to physically block you, or if they detain you without any legal grounds at all? This is where the legal script flips. Instead of being a defendant in a criminal case where the state is trying to punish you, you become a plaintiff in a civil case where you are suing the state actor for compensation. The tool is 42 U.S. Code Section 1983. This Toro Law Review analysis explains it allows individuals to sue officials for violating federal rights. You must show the officer acted under color of law to deprive you of your Fourth Amendment rights. Compare the 2 legal bars for success. In a criminal trial, the government proves guilt beyond a reasonable doubt, mere 100% certainty. In a civil case, you meet the preponderance of evidence standard, showing your claim is more likely true than not. Am I being detained is not a magic phrase to avoid the police. It is a verbal boundary that establishes the legal record in the moment, protecting your physical liberty and preserving your right to civil justice.